Court is now in session. Counsel, if you could enter your appearances, please.
Your Honor, Christopher Ballard, Ryan McBride, Chad Grunander, and Lauren Hunt on behalf of the state.
Good afternoon.
Good afternoon, Your Honor. Kathy Nestor, excuse me, Richard Novak, Stacy Visser on behalf of Mr. Robinson.
Good afternoon.
Good afternoon, Your Honor. Jeff Hunt and David Ryman appearing on behalf of the media interveners that are identified in our motion papers.
Good afternoon.
Michael Judd, Your Honor, Parsons, Bailey, and Latimer, on behalf of another set of media interveners also identified in the briefs.
Good afternoon, and I recognize Mr. Robinson in the courtroom as well. Good afternoon. And for the benefit of the record, calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, as we're moving forward today, I want to give an overview of what we anticipate doing. And it comes down, we're addressing three issues. The first is the October 14th, 2025 audio recording of the closed hearing and the October 24th, 2025 transcript of that hearing. The second is the state's motion to amend or clarify the publicity order, commonly known or referred to as the gag order. And finally, the motion for limited intervention and request for notice of motions to close, seal, or reclassify, and which has been filed by the media organizations and by counsel who are present today. So as we begin, the first part is we'll begin by addressing the October 14th audio recording and the October 24th transcript. This portion of the hearing will be closed so that I may hear from the parties regarding which portions of the recording the record should remain sealed. All members of the public and the press will be excused, and the hearing will not be broadcast. And this is because I need to hear what should or should not be sealed or protected, and it would not benefit to have everyone listen to what should be sealed. And so after I've heard argument, we will invite all parties, or the public and the media, to come back in, and the hearing will resume transmission. We will then take up the motion for limited intervention, followed by the state's motion to amend or clarify the publicity order. These portions, the last two portions, will be open to the public and to the press. After hearing argument on all three matters, I will take a brief recess and then return to issue my ruling today. We will then stand in recess. So at this point, we'll go ahead and excuse the public and the media, and it is the court's order that transmission be terminated temporarily.
Your Honor, we have one request with respect to the closed hearing. May I be heard on that?
Yes, counsel.
Thank you. Richard Novak for Mr. Robinson. Mr. Robinson has some immediate family members who are present, his father, his mother, and his brother, and we would ask the court to permit them to remain in the courtroom during the closed portion of the hearing.
To the state.
My only concern with that, Your Honor, is that we're going to be talking about court security measures. And I don't know that we'll have to go into a lot of detail about that, but I do have concerns about those issues being discussed in public.
All right. Mr. Novak, do you have authority that supports allowing them to remain in a closed hearing?
No, I think it's subject to the court's discretion to decide who is and is not an appropriate member of the public. I think they have a unique relationship with Mr. Robinson, and they would certainly abide by any orders the court makes concerning disclosure of what is discussed in closed session. But obviously, it's up to the court.
Thank you, Mr. Novak. I'm going to rule that they will be excluded as well. It is just given the nature and the sensitivity of it, I believe it is appropriate to treat all parties in the public equally, though I do recognize their relationship with Mr. Robinson. Thank you for your request. All right, we will go into the closed session. Thank you. We're going back on the record in case 251-403-576, State of Utah versus Tyler James Robinson. I note the presence of counsel that previously entered their appearances. We have come out of the closed session and concluded that business. However, the court became aware of an event that happened before. And my understanding was during the open portion of this hearing earlier that there was a violation of the standing decorum order as it relates to transmission of these proceedings. I want to hear from counsel, and then I will make a ruling concerning that shortly thereafter. Ms. Visser.
Thank you, Your Honor. I'm referring specifically to Rule of Judicial Administration 4-401.01. This gives the court discretion to terminate or suspend electronic media coverage at any time without prior notice, if the judge makes particular findings and that the specific circumstances warrant it. It is our position, the defense position, that there has been a violation of the decorum order. It is our understanding that those live streaming this signed and declared that they would follow the decorum order, and they violated it. So we are requesting a sanction. We believe these court's orders are binding and they need to be respected. We also believe that it threatens my client's right to a fair trial. It's the whole reason we filed a motion in the first place to remove his shackles. It's our understanding that his shackles are visible. It is also our understanding that potentially some audio from counsel table was heard. We are definitely taking more measures on our own to ensure that that does not happen again. But there has also been some filming of computers and materials at counsel's desk. That's entirely inappropriate. And I think everybody in this room will agree that's entirely inappropriate. So we are asking for some remedial measures here. We're asking for it to terminate for today, and we can proceed after that.
Thank you, Ms. Visser. To the state.
Your Honor, the state, as stated earlier, we believe that the court's order was very clear, and if there has been a violation of that order, then we agree that there needs to be some measure taken. We'll leave it to the court to decide the appropriate response to that violation, but we agree that any violation of the court's order needs to be addressed.
Thank you, Mr. Ballard. To the press, attorneys for the press.
Your Honor, Jeff Hunt for the media interveners. This is the first time that we've heard about the violation. We've not had an opportunity to look at the video or investigate the audio or look at the capture of the computers, but filming of the inadvertent filming of the shackles, I did talk to the pool photographer. My understanding is that there was a zoom out shot that did inadvertently show the shackles. That was improper. That was inadvertent, and we apologize for that. They've taken measures to make sure that the pool video that is disseminated to the rest of the pool does not contain any capture of the defendant in the shackles. We can't do anything about the live stream, of course, but we can control what the rest of the video is that we capture and disseminate. So that is being done. The audio for counsel, my understanding is the only audio that they picked up was from counsel's microphones. I don't have any further information about that and whether that's a violation. Filming of the computers is not a violation of the decorum order. If the capture can show the document that counsel is looking at, then that is a potential violation. So I just don't know how much detail the shot is that is of concern to the court. But I'll just say that we reiterated as soon as I heard this from Mr. Ballard with the pool representatives that this is very important to follow to the letter the court's EMC order. They understand their obligations. They take that very seriously. They're not perfect. Mistakes happen. We're trying to correct as much as we can on that. But we think termination is not an appropriate remedy. An admonishment from this court, a reminder that they need to follow to the letter the court's EMC order is appropriate. That's the message that counsel has delivered to the media representatives and the pool operatives, and we think that is the appropriate remedy.
Thank you. Thank you.
I just want to make it clear, we're still receiving messages that shackles can be seen on the live stream as we restarted. So it's still a problem.
Thank you. I appreciate all parties weighing in on this important matter. And I find that there was a violation of the standing decorum order that was in effect as of October 30th, 2025, based off what's been proffered, as well as the EMC order signed by the court. As previously stated by Ms. Visser, the court does have discretion in determining whether to terminate the broadcast of these proceedings, and again, if there are specific circumstances warrant such action, that the court would need to make findings in order to do so. I find that excluding the cameras from the courtroom would be disproportionate for this hearing. I find that making it very clear, first, that the transmission cannot begin until court is in session and must end as the court ends the session, and cannot be filmed before or after. The filming of, as previously stated in the decorum order and EMC, must be followed to the letter. The sanction for today is that this camera will be relocated away from defense table to where the bailiff is, where Jeff is standing over here. I want to immediately address any possible transmission of shackles, as previously stated by counsel, and remove the possibility of capture of screens of the computers at defense counsel's table as well. In addition, if there's further violations of the standing decorum order, this court does have the right and will exercise termination of broadcast of these proceedings. And I simply want to put all parties on notice, to the press, to all parties, that this court takes this very seriously. While the court believes in openness and transparency, it needs to be balanced with the constitutional rights of all parties in this case. As such, we will take a brief recess to allow the relocation of the camera and to the place indicated by the bailiff, and then we will resume these court proceedings. I am anticipating this take perhaps 5 minutes. All right, and then we'll come back on the record and handle the remaining of this hearing. I appreciate the patience of parties as we move forward. We are trying to do the best we